Welcome to the Military Justice Today podcast with your host, Robert Capovilla and Mickey Williams, covering the full range of military law topics from all branches of the armed forces. Today's episode is made possible in part by the law firm of Capovilla and Williams. And now, let's welcome the hosts of the show, Rob and Mickey.
All right, everybody, we are back in the studio for another episode of Military Justice Today. I'm Matt Starosiak, sitting across the podcast table from none other than Robert Capovilla. Hello, Robert.
Hey, Matt. How you doing?
I'm doing great this morning. How about you, sir?
I'm doing good.
Yeah, you kind of look like you have the eye of the tiger this morning. Aren't you doing some kind of race this weekend or some kind of fun run or something? You got the eye of the tiger looking at me.
Well, I might have the eye of the tiger. That's probably more related to some things going on in the business world and with military justice. I am running a 5K this weekend.
I thought it was a 10K.
No, I'm not going to be able to get there in time for the 10K, so I'm going to do a 5K.
I see.
And it's in LJ, Georgia, so it's supposed to be a really beautiful run. And I'm excited to do it. When I left the U.S. Army, I used to routinely run about 40, 50 miles a week, and I would be able to knock out 10, 15-mile runs. Well, that's an exaggeration. I'd be able to knock out 8 to 10-mile runs pretty easily. And then, things happen. You get a little older, you start a business, you get busy trying cases, you get married, and you lose some of that agility, you lose some of that endurance. So I'm working on getting myself back in the kind of shape that I can be proud of as I slowly approach the next milestone of my life, which is 40.
It's not going to get any easier once you reach 40. You realize that?
Well, nothing gets easier. And that just means you got to do it harder, right? I mean, that's the whole purpose of life is when things get hard, you do them hard. And I just love to do it. It's a very free feeling. It's a stress. It relaxes me, right? It reduces the stress. And honestly, some of the best ideas I've ever had in a courtroom came from my morning run. So I love being outside.
It does tend to clear the head. Any exercise, I guess, does. The real issue of the show today, which are rules of evidence, I think we're going to cover, right?
Yeah, we're going to cover some of the 100 series rules of evidence today and talk about some really important aspects of those rules that I don't think counsel know much about. We tend to skip over the 100 series, right? Everybody wants to go to the 400 series, the 600 series, the 800 series, or the 900 series, and we fail to realize that the 100 series actually serves as the foundation for a lot of what we know about the procedural aspects of evidentiary law. And there's some keys in there that you got to know if you're going to do your job at a high level. And if you don't know them, hopefully at the end of this podcast episode, you will know them.
Give us a little bit of background just for those that are not as well versed in this subject matter as others, exactly what we're looking. We're looking at the federal rules of evidence, or there's a specific rules of evidence that controls what happens in the military courts. Give us a little bit of foundation, and then let's jump into the specific ones that you really want to talk about.
Yeah, so we're talking about the 100 series from the military rules of evidence, which do mirror the federal rules of evidence in a lot of ways, but given that there are some certain peculiarities with military law, they do differ. So we're talking about the 100 series, and we're going to discuss primarily in this podcast, we're going to discuss MRE 103. We're going to talk about MRE 104. I think we're going to touch a little bit on MRE 105, and then we're going to finish with MRE 106. But this section starts off the rules of evidence, right? It's the first, section or chapter. It's called the general provisions. So it's section 1, general provisions. And it starts with MRE 101 Alpha, which essentially talks about the scope of the rules of evidence. It talks about the sources of law. It talks about the secondary sources of law. And then it extends all the way into the 106 series, which is a very, very important rule for any trial lawyer to know, and a rule that, if you know it well, can really help you in trial if you know how to use it to your advantage.
Is this 100 series, is this the logical starting point, the foundation that you need to be successful in the courtroom when it comes to the rules of evidence? I mean, I guess what I'm asking is this in the right place in the manual? Is this what everybody needs to understand first before you get into the more complex stuff later on, or not so much?
I wouldn't necessarily say that. I think that if you have limited time and you're a new JAG and you're thrown into the courtroom right away, which happened to me, right?
Probably happens the most.
Which happens the most. Within 2 weeks of being a trial counsel, I found myself in a case that had like 20-something witnesses from a 15-6 investigation that probably should have never went to trial. And quite frankly, we got our butts kicked in that. And shout out to my good friend Nathan Freeberg, who's also a civilian and does what I do. And I faced him for my first ever
he gave
trial
you the butt
as a trial
kicking, did
counsel. He did, and actually used some of these rules that we're going to be talking about today to his advantage. But no, I think if you're a brand new trial counsel, you need to start with the 400 series. You need to understand relevance. You need to understand legal relevance, logical relevance. You need to understand character evidence, what it is, when it's admissible, when it's not admissible. You need to understand 404 Bravo. And then if your time is limited, you need to shoot into the 600 series, understand personal knowledge of witnesses, understand what impeachment is, understand how to do that. And then from there, I would go to the 800 series, which are your hearsay objections. You got to understand those. You got to understand, what the exclusions are, what the exceptions are. And then I would move from there to the 900 series, which is the rules for admissibility in terms of foundation and authentication. However, what I would also say is, if you are a trial lawyer practicing in military courts martial, you need to read the MRE, the manual from front to back, and you need to do it frequently, and you need to do it at least 3 or 4 different times, the more senior you get. And you've got to understand these rules like the back of your hand, because especially as a defense lawyer, the last thing you want is to lose a trial that you should have won because you made a procedural mistake.
Yeah, and it moves fast during the trial,
does,
right?
100%. And sometimes the branches on appeal, right, the appellate divisions, those folks can be rather unforgiving. They tend to be pretty exacting, and if you want to avoid an IAC issue, which if you try cases long enough, you're not going to avoid all of them because you're a human being and you're going to make tactical decisions that the folks up there that judge us in the courtroom won't agree with. But
IAC being ineffective assistance
counsel, right? Which on the state side is not it almost never comes into play unless you are truly negligent in your duties. On the military side, they nitpick everything. So you really got to know your rules of evidence. But the 100 series, I remember reading these as a captain, and I remember thinking, wow, I've heard about instructions. I've heard about the rule of completeness. I've heard about officer proof. I sort of knew what I needed to do for an objection. I sort of knew what I needed to do for instructions. But all of that, the foundation for that is all found in the 100 series, including why the judge rules the way, what powers the judge has to rule on interlocutory questions, which are better known as, questions we bring up as attorneys in motions hearings and Article 39 alpha hearings. So it's a set of rules that if you know it and you know it well, will give you an advantage because your competition is probably not going to know it.
Yeah. So what I hear you saying is that there probably are other sections or series that are more important than the first series, but this one is something you don't want to overlook.
That's correct. You need to know, if you're serious about being a great trial lawyer in military courts, you need to know all of this, plus the case law, plus the local rules, plus the rules of practice, plus
being
the
able to read the room as you're doing it.
Plus the RCMs, because military court is it's very procedural, it's very formal. There's things you have to do to be successful in military court that the federal courts that I've been in front of, and I've been in front of numerous now, and the state courts that I've been in front of would sort of laugh at, but in the military, they take it very seriously.
All right, so this 100 series, are we going to pick your favorites? We're going to pick the ones you think are most important? How are we going to cover them?
Yeah, so we're not going to go over every single one. We're going to go over the ones that I thought were most important, that if I were a new counsel, I wish I would have known this when I started practicing in military courts. So without further ado, I think we'll start with Military Rule of Evidence 103 Alpha 2, and really just 103 in general. And here's why Alpha 2 in particular is important to understand. So Military Rule of Evidence 103 Alpha applies for or allows you to put forward offers of proof. And what are we talking about here? Okay, you're in the courtroom. You're in front of a panel. It's trial time. You want to admit a piece of evidence, okay, whether that's documentary evidence or whether that's evidence via witness testimony. and the other side objects, and the judge sustains the objection.
So it's not coming in.
It's not coming in. The judge has made a determination to exclude the evidence. Okay? What rights do you have at that point in time? Because if you've tried cases long enough, you know sometimes judges don't even really give you much of an opportunity to be heard. Sometimes, and this is more prevalent in state court and federal court than military court, they'll just say sustained. But I've had that happen in military court as well. Or I'll have it happen in military court where they won't let you say much, right? In particular, as a defense lawyer, sometimes you know some things about the case that maybe the government doesn't know, and it takes a while to build up that, let's say, that motive to fabricate through a direct line of questioning. And sometimes the judge will make a determination, no, from what I've heard so far, that's not relevant.
And they don't know the rest.
And they don't fully understand it because, look, you know, there's no requirement that says you have to tell the government and the military judge every aspect of your case beforehand, even though I think that's where we're going in military justice. I think the rules are getting to a point where defense counsel might as well just say everything they're ever going to do because otherwise it's a fight. But let's say you've got a motive to fabricate. Let's say you found out that this particular witness was involved in a bad deal with money with your client, right? Where they think your client stole $500 from them, and now they're the guy up there saying, yeah, they heard you or they saw you assault this person, and you have a clear motive to fabricate under 608 Charlie. And you start going down the line of this financial transaction that went bad, and the government objects, and the judge says, defense counsel, what the heck are you doing? You know, sustain, this is not relevant. At that point in time, you must, to preserve the record clearly, you must put forward an offer of proof under Military Rule of Evidence 103. Okay.
And I would assume the purpose of that is to establish a record so that it can be reviewed later. Is that right?
Well, that's part of the purpose, but the other part of the purpose is you want to be heard to explain why the evidence is relevant to begin with.
Okay.
And you have a right to put that out there in front of the judge. So the way that works is, and I've done this, I don't know, 24 times, okay? And I've never had a judge deny me because if the judge knows the case law, they're aware of U.S. versus Hayes, which is 15 MJ 650 is the site that says, hey, judges, when you get an offer for proof, you better let counsel have their word. Otherwise, there's going to almost certainly, and it really gets that aggressive, almost certainly be a finding of prejudice. So in this particular case, right, let's say I have a reason to believe that the witness dislikes my client because of a bad financial transaction. What I would do there, is if it's in front of a panel, you can risk putting the offer of proof in front of the panel. Tactically speaking, that's probably not a bad idea because, you're going to tell the panel almost a free shot at kind of a closing argument, right? And it would go something like this: Your Honor, I'm establishing a line of questioning to show that this witness, has personal knowledge about a financial transaction with my client where he accused my client of stealing $600 from him. And that is a motive to fabricate, and that is admissible under MRE 608. 608 Charlie specifically. When you do that, the judge is going to be hard pressed not to allow you to go down that line of questioning because case law says the judge has to take a liberal viewpoint when it comes to MRE 608 Charlie. Yeah. Now, the judge is probably going to get a little ticked off that you made this argument in front of the panel. So you can I
can't believe that can be made in front of the panel. I would think that if you ask to do an offer of proof, by default, the panel has to leave the courtroom. But you're saying that doesn't happen.
No, they should. The judge should. And
because how do they not consider that evidence if the judge, after you finish, still says it's not coming in, it's out there.
Correct.
It's out of the bag.
And that's the benefit of doing it as a defense counsel. Yeah. The probably more proper way to do it is to request an Article 39 Alpha where you say, Your Honor, I want to put forward an offer of proof. They excuse the members, and we're actually talking about some of this later with some of these other rules in the 100 series. The judge would excuse the members. We would then have the discussion. I would present my proffer, my offer of proof, and then the judge would make a ruling at that point. And you've accomplished two things. Number one, you've clearly let the judge know why there's a nexus between this line of questioning and the charged offenses, right? And then number two, you've also clearly, specifically, and timely made an objection to the judge's ruling to exclude evidence so that if they don't admit it, Nobody's going to come back on the back end and say, Mr. Capovilla, it really wasn't clear that you were making an objection here,
Right.
which is the kind of stuff that they do sometimes. And so you're protecting yourself, and you're also putting your client in a position to be successful, which is really what your job is.
So a couple questions. One, in your estimation, how often does the judge change his or her mind after the offer of proof? Because they have the ability to do that, right? They can listen to what you say and say, okay, well, I sustained that objection that it wasn't coming in, but now I hear what you've said, counsel, and now we are going to let it in. How often do you think that happens to you personally and just from your own experience of others?
That's a good question.
Of course it is. I do nothing but ask good questions.
No, that was a good question. And here's what I'll say. That's a matter of preparation. That's a matter of preparation. If you are a cross-examiner who wings it, you're not going to be successful. I don't care who you are. I can't tell you how many times we've seen appellate records of attorneys that seem totally unprepared, whether it's just laziness or a lack of experience to cross-examine. When you're cross-examining, here's a free tip, especially if it's a sex assault case or a case involving an alleged victim. Next to every question, I mean, literally, I do this, okay? And I'm as busy as any of you folks out there, trust me, okay? And I do this every trial. I break my questions down into chapters, and I break those chapters down into tables, and I have my question in one column. Next to my question, I have the citation, where it can be found in case I've got to impeach on a drop of a hat. And then the third column, I have relevance. Why is it relevant? And sometimes I'll even write out case law in there and make an argument so that if there is an objection or if I do have to do an offer of proof, I have everything I need right there. Believe this or not, I can't recall a single time I've offered proof under 608 Charlie motive to fabricate where the judge has not granted my request. There's been a couple times where I offer proof for something a little different than a motive to fabricate, and I don't have a great memory of all of that, but I don't have a single memory of losing an offer of proof because I was ready.
I think it's probably a good opportunity to plug that episode we did on your trial prep and your question prep, because you and Mickey talked through that one time on a podcast. Now, it's been a minute since we've done that one. I'm not sure whether it's still up on the podcast platforms, but it was a great episode talking about what you just talked about, how you put the tables together and you've got all the information. So anybody who's more interested in learning exactly how that or hearing about exactly how that's done should grab that episode, and we'll try to put a note out there on our Facebook page or LinkedIn page as to where it's at. But sorry to interrupt you there, Robert, but go ahead.
No, I mean that's the basics, right?
The offer of proof.
Yeah, MRE 103, offer to proof. And look, don't be afraid of the military judge, folks. I don't care if you're a captain. I don't care if you're a lieutenant. Don't be afraid of the military judge.
Yeah, because a lot of people worry that they're going to get pissed off, right? Because now you've challenged their ruling in even a more unique way.
Yes, I mean, I've been in some jurisdictions where both sides are so afraid of the military judge that it's striking to me. You don't have time to be afraid of the military judge. You got a big job, whether you're prosecuting a service member or defending a service member. You got to have the guts to stand on your own 2 feet. And the guts and courage to do that comes from knowing your rules of evidence. I've had a lot of judges who maybe don't like civilians in their courtroom. Maybe they've heard I'm difficult to deal with. Maybe they think,
way.
I mean,
No way.
It's possible, right? Maybe they're just, maybe they're just the kind of judges that have curious minds, right? But what I've noticed is when you come into authority, when you can answer questions with authority, you will gain the respect of the judge. And that'll help you down the road in any time you're before that military judge again. Even if they don't like you, even if they think you're over the top or this or that, they're going to respect your preparation and your understanding of the rules.
And I guess for opposing counsel, if they haven't figured it out already, they know you mean business because you've come prepared, you know the rules, you know how to do this stuff and execute it at a high level. So now they're figuring out, we better have brought our A game to this trial. Yeah,
that's probably true. I mean, that's probably true. I have certainly felt the tone and tenor of courtrooms change. I think that there's an idea amongst JAG officers, trial lawyer, trial counsel and defense counsel, the military, that us civilians are undisciplined, that we only care about the money, that somehow we forget our ethics at the doorstep. We forget the things we learned as military officers. And I think sometimes they're surprised that we're as prepared as we are. some of that comes from they've had bad experiences with civilian counsel who are bad.
Yeah.
But, we take a lot of pride at Capovilla Williams that when we step into a courtroom, this is our third core value, zealous advocacy. It literally says in that core value, you will know the rules of evidence better than your opponent, and you will be the best trial lawyer in any courtroom you walk into, period. And I think we do a pretty darn good job of that. Just last quarter alone, I think we had 4 acquittals and court-martials, and we won 4 boards. And so I'd like to think we do a good job at that. Nobody's perfect. We all have our bad days. But yeah, knowing your rules of evidence it's sort of like, Dan and Mickey at our firm and Robbie were infantrymen, right? And if they didn't understand their weapon system in combat, they'd be in deep shit.
Yeah, right.
You know what I mean? And it's the same with rules of evidence for a trial lawyer. If you don't know your rules of evidence, get out of the courtroom. Don't waste the time of the judge. Don't waste the time of your opponent. Don't waste the time of your client. Just admit you don't know the rules and be done with it.
Yeah.
It reminds me of the movie, a very old movie now. Do you remember the movie Ghost in the Darkness?
No, never saw it.
Ghost in the Darkness
Sounds weird.
Yeah, Ghost in the Darkness was a movie with Val Kilmer and Michael Douglas about the Lions of Savo. The Lions of Savo were the group of 2 male lions that, as Great Britain was building the railroads through Africa, these lions attacked and killed like more than 100 of these workers. They were hunting and killing human beings. They actually have these lions are now mounted at the Smithsonian or something. You can go look at them. And after a while, the natives felt the lions were possessed by demons. They felt they were demons. And so I think the guy who's Val Kilmer plays is, I think, Lieutenant Colonel Patterson, I think is his name is. And Michael Douglas's character, I think, is made up. I read this book a long time ago, but he plays a guy named Remington, who's like this famous man's man, like hunter, almost like Hemingway or something,
yeah.
Right? Or like Peter Hathaway Capstick, like this famous hunting guide. Anyway, this is a long story to get to a short point, but when Val Kilmer's character and Michael Douglas's character first hunt together, Val Kilmer uses a rifle that was given to him by somebody else, and he had never fired it before. And he has one of the lions, dead shot, 20 yards broadside, and he squeezes off, and the weapon doesn't fire. And Michael Douglas, when the lion gets away, and Michael Douglas looks at him and says something like, "You came to battle with a weapon you weren't familiar with."
Yeah.
And that's kind of the way it is for military rules of evidence. Like
it's like that for a lot of things in life, though. It's like never play football or anything with cleats that you haven't worn, and broke.
100%. Don't do a ruck march in new boots, right?
Yeah, it's very simple stuff, but
it is.
It's amazing how often people will make that foolish
But in
mistake.
adversarial situations where you're under a tremendous amount of pressure anyway, like hunting a lion or defending somebody of a serious crime in a contested trial, it becomes more important to know your basics, because you will lose some of as you get tired, as you start to get to wear down, as the pressure starts to get to you a little bit like it does to all of us, you need to know your rules of evidence. You need to know your basics.
All right, well, let's move on to the next one here on your list that you want to talk about, because I know there's more than just the one.
Yeah, so the next one we're going to talk about is Military Rule Evidence 104. And whether counsel know this or not, they deal with MRE 104 every single time they step foot in an Article 39A session. Every single time they file a motion in limine. Every single time they litigate a motion, whether that's before trial or during trial, or sometimes even post-trial, right? So MRE 104 is the rule of evidence that gives the judge the power to rule on the admissibility of evidence. Okay? So if you ever wonder, wait a second, we just assume the judge can rule on these issues, right?
Yeah, if the judge is not doing it, who is doing it?
Exactly right. Well, MRE 104 is the rule that gives them that authority, but there's more to the rule to understand.
I would hope so.
Okay? So the judge should, it literally says, the judge should resolve evidentiary issues outside the presence of the members. Members must be excused on any argument dealing with the admissibility of the accused statement or when justice requires it. Now, why is that important? If you're a defense lawyer, which I've been now for a long time, and this would be applicable to trial counsel who listen to this too, but as a defense lawyer, if there is any question at all about the admissibility of your client's statement, and the panel hears that, that is your failure. The rule is very clear. If there are any questions dealing with the admissibility of the accused statement, given how sensitive it is and how much the accused has to lose, that must not happen.
Must
not happen in front of the court members, in front of the panel. If the prosecutors bring it up in front of the panel unnecessarily, okay, then that's grounds for a potential mistrial. Hold on, though. I see you want to ask me a question. There's another aspect of this rule. Or when interests of justice require, members must be excused on any argument dealing with the admissibility of an accused statement or when the interests of justice require. Okay, you're a trial counsel. You're a defense counsel in the Army, Air Force, Marine Corps, whatever, right? And there's evidence that you don't want the panel to hear that has seeped its way into trial, whether that's a witness who you're a little bit concerned about. Let's just use that example. Let's say you've got a witness that you interviewed late in trial, they were difficult to get a hold of, and they're going to say something that you don't think is admissible. You have certainly the right to request before that witness is called to the stand to voir dire that witness outside the presence of the panel members to ensure inadmissible evidence is not heard by the panel. And if the judge says, well, I'd like to wait, because they do this, well, I'd like to wait and let's see where it goes.
Yeah.
I always push back on that. And I say, Your Honor, MRE 104 is very clear that when the interests of justice require argument, or in this case, we're requesting to voir dire a witness, it should be done outside the presence of the panel members.
Because it can't be unheard.
It can't be unheard. And judges will say all the time, well, if it comes out, we'll give a limiting instruction. Limiting instructions are fine. It doesn't fully cure anything.
No.
And it's much safer to just have these discussions outside of the presence of the panel. So let's say you have a witness that you think is going to bring up something inadmissible based on pretrial notes. You need to request an Article 39 alpha to voir dire that witness to make sure that does not come out. And if the judge pushes back, you say, Your Honor, MRE 104 says that these issues should not be heard in front of the panel when the interests of justice required. And ma'am, if this evidence is heard by the panel, even inadvertently, we will request a mistrial. Now, sometimes, tactically speaking, you may want to let it in to request a mistrial if you don't think things are going so well. But usually, I always tell folks, be upfront. Typically tricks and games come back and get you to some extent. So that's an important rule to understand. I know you had a question.
I do. Well, I have two questions. One, I can think of a million things that you've said to me in my life that I can't unhear. So I know exactly why this rule exists. And then the second thing is when you said when it involves a statement of the accused, what's considered a statement for that purpose? Are we talking about the statement that they might give to CID or some investigative body? Or are we talking about any statement they may have given at any time to anybody? Is there a limitation on that?
I would argue it's any statement given at any time to anybody, because under the rules in military courts, Article 31 Bravo is applicable to any service member. So if you have any question about the admissibility of your client's statement, that must be heard outside the presence of the panel.
Okay.
And, for obvious reasons, right? I mean, people get convicted on what they say all the time. Yeah. So we've got to be very conscientious of that. Now, there's a few more aspects of MRE 104 that are important to understand. The next one is that when it comes to ruling on the admissibility of evidence, the military judge does not have to consider the rules of evidence. I see counsel get this wrong, and I see you looking at me inquisitively.
Yeah, that sounds very weird.
I will tell you what this means, okay? I see counsel get this wrong all the time. It's a complex way to say something simple. When the judge is deciding on whether a piece of evidence should be admitted in an Article 39 alpha session, the judge is not restricted by the rules of evidence. In other words, the rules of evidence are not applicable in a motions hearing. Now, obviously, your privileges in things like that are applicable, but generally speaking, the rules of evidence are not applicable. So here's what I mean. Let's say you want to admit evidence to a motive to fabricate in a particular trial, and you have an eyewitness who heard from a third party that the alleged victim made an accusation because she knew she was getting in trouble with the Air Force and she wanted her benefits, so she decided that she was going to make this allegation because it would help her get out with her benefits. Now, that's technically hearsay, right?
Right.
The alleged victim tells a third party tells your witness. Government stands up in the motions hearing. 39 alpha, objection, Your Honor, hearsay. And they're very proud of themselves, right? That's right. It's clear hearsay. MRE 104 is applicable and clearly says the judge does not have to consider the rules of evidence when ruling on whether or not it's admissible for me to argue that motive to fabricate or to ask the alleged victim about that motive to fabricate. So my response would be, yes, Your Honor, this is hearsay. However, pursuant to MRE 104, we're in an Article 39 Alpha hearing. You are not restricted by the rules of evidence to make a ruling on the admissibility of this test.
How often do you have to make that argument right there?
Almost
it sounds
all the time.
like people don't know. And it makes more sense now that you've described it. You obviously can't limit it. If a judge is trying to decide whether something is admissible, you can't then start limiting the judge on what they can hear while they're making that decision. It makes sense.
Right.
But it also seems to me that most people would know this rule and it would be completely understood by the folks in that, I'm going to call it a sidebar, discussion or out of the presence of the panel discussion. You're shaking your head like, no, they don't know.
No, I've gotten a number of objections to things like hearsay during a motions hearing. And that's my response. And the judge 90% of the time says, yep, overruling the objection. I'd like to hear this evidence. Now, to prove up to during an Article 39 Alpha, if you're going to try to admit a piece of evidence or show why it should be admitted, your questions have to be relevant for that purpose, right?
Yeah.
And the judge doesn't necessarily have to hear anything you have to say on it. But the rules of evidence are not applicable, and mostly that centers around things like hearsay. The judge can absolutely hear hearsay evidence when determining an interlocutory question.
So, should there ever be any objections at all in a 39?
Yes, yes,
or is it really just a free forum? But there can be objections.
Absolutely. So, we get objections all the time under MRE 412 and 412 hearings where. That the government accuses the defense counsel of asking questions that are not applicable to the actual 412 motion. They're digging for discovery. They're digging for more information. So the questions you ask have to be relevant to the purpose of the hearing, right? So if you file a motion to pre-admit something, you're not allowed to just call the witness up there and do a 3-hour, interview with them on everything they ever heard or knew about the military, right? You have to ask questions that are relevant for the judge to decide the issue. But if they're relevant for the judge to decide the issue, the judge is not bound by the rules of evidence. They're not bound by hearsay. They're not bound by best evidence rule. They're not bound by those things. It's simple. Is it relevant for the judge to decide the question? And that's it.
Yeah.
And if the answer is yes, the judge should not limit you. Now, there's other things that come into play too, like privileges, right? The judge is not going to violate a privilege or whatever. But the basic rules of evidence that we deal with every day for admissibility under MRE 104 are not applicable when a judge determines the admissibility of evidence.
All right. Was there a second point to that you were going to talk about as something noteworthy?
Yeah. So MRE 104 Delta is very important, especially for a defense attorney to understand. And in fact, I would say if you don't know 104 Delta as a defense lawyer, you're setting yourself up for some real failure. And this is an absolute rule you've got to know. So here's what 104 Delta says. An accused can testify on a preliminary question, or when an accused testifies on a preliminary question, they are not subject to cross-examination on any other topic. If you call your client to testify about why you feel his statement to CID or OSI or NCIS is inadmissible, or if you call your client to testify at an MRE 412 hearing because there were only 2 people in the room when the sexual assault happened, and he knows about the text messages and the phone calls and everything else beforehand, the government cannot cross-examine him on other matters. And you have to be very diligent at Article 39 Alpha hearings when you call your client. My favorite thing to do is to submit an affidavit, but some military judges don't let you do that, which I think is ludicrous, but they don't. So, if you call your client on the stand to settle a preliminary question on the admissibility of something, or you want to exclude or suppress his statement, or you want to get something admitted through 412 and you call him to testify, the government cannot use that as an opportunity to prove up their case. I had this happen recently in Army court where my opponent was a lieutenant colonel, and I called my client to testify about 412 matters, and the government wanted to use that as an opportunity to help prove up some conduct unbecoming allegations they had charged. I immediately stood up. I cited the rule for the military judge. She took about a 15-minute break. She came back in. She sustained my objection.
What do you think she was doing?
She was probably researching the issue because it wasn't quite that simple.
Yeah.
But the bottom line is, when you call your client to testify during a preliminary hearing on Article 39 Alpha, the government is only able to question them on the topic for which you've called them.
As to be contrasted with the actual trial, when if you were to call your client, they could be cross-examined on issues as long as those issues are relevant.
Right. There's some additional protections for a client who testifies during the merits. For example, they may elect to just testify to certain charges and retain the right to remain silent on others. But that is correct, right? At trial, anything dealing with their credibility would be admissible. Anything that's relevant to the charged offenses is admissible. At an Article 39 Alpha session, the rules want to encourage an open exchange of information, so they give the accused certain protections that he would not have at trial. And here's the other thing that people need to realize. Now, this is not an absolute rule, but Dave Schluter's book, the manual,
back, by the way.
We do.
Yeah.
The manual on the rules of evidence talks about this and cites some case law. But the government is pretty much prohibited from using any statements your client makes during an Article 39 Alpha later against them.
Interesting.
Even if it's for impeachment evidence.
Really?
So, yes. So that's unique because the courts want the truth, and they don't want your client to be so afraid to say anything that they can't get at the truth, right? I mean, MRE 102, which we skipped over for purposes of today's podcast, talks about the purpose of trial is to ascertain the truth. And so we want as a society a process that helps us get to the truth. And that's why MRE 104 Delta exists and says what it says.
So some additional protections, I guess, for the defendant in some of these hearings is what I'm getting, gathering. Some additional protections for that.
Correct.
Yeah.
And that's because despite what a lot of victim advocates want us to believe, the only person who has true constitutional rights as an accused sitting in that courtroom is in fact the accused.
Yeah. All right. Well, what's next on our list?
Yeah, so the next one is relatively simple to understand. The next one is Military Rule of Evidence 105. And this is where we get some authority for our limiting instructions. So we've all dealt with anybody who's been in military court for a short period of time or for a long period of time, anybody who's spent any time in military courts has dealt with something like MRE 404 Bravo, right? Uncharged acts of misconduct or uncharged acts, doesn't necessarily have to be misconduct, that are used for limited purposes like to show the accused has a motive to commit the crime, an intent to commit the crime, opportunity to commit the crime, knowledge to commit the crime, right? So 404 Alpha says character evidence is impermissible. We can't say just because somebody did something bad before, they've done it bad now. 404B serves as a very broad exception to that rule that says certain uncharged acts are admissible for this limited purpose. Well, MRE 105 is where we get the idea for that limited purpose. And MRE 105 permits evidence to be admitted only for a limited purpose. However, counsel must request instructions, and those instructions requests must be done specifically. Now, this sounds pretty simple, right? And it is, but it's important. Right? So let's say you do have MRE 404 Bravo evidence admitted against your client. Do you request an instruction at that point to educate the panel on what 404 Bravo is? Do you wait until the conclusion of the trial before closing argument to request the instruction? That's a tactical decision every counsel has to make, but the ability for the judge to issue limiting instructions, to tell the panel, hey, this evidence can be used for this purpose, but not this purpose, is found in MRE 105. And there's also, MRE 105 also gives lawyers some guidance on how to request those instructions. They have to be specific. They have to be clear on what instructions they're wanting. And this is important because if I had $1 for every time I sat in court and the judge admits MRE 404 Bravo, because there must be some mandate out there somewhere that says all MRE 404 Bravo must be admitted at all times.
You're going to get yourself in trouble here, Robert.
I know, and I understand. I know, and I understand the congressional intent behind it. I get it. It's a rule of inclusion, not exclusion, all this kind of crazy stuff. But if I had $1 for every time government counsel got up on closing argument and argued 404 Bravo impermissibly as 404 Alpha character evidence, I'd be a much wealthier man than I am right now. And that's why you've got to understand your instructions. You've got to make the tactical decisions when to instruct the jury if you want them instructed. And you've got to know what the use of limited evidence means, right? And limited evidence comes into play with 404B. It comes into play with impeachment evidence. It comes into play with 413 evidence, with 414 evidence. It's something you've got to understand. You've got to understand the limited nature of evidence and what that means for your ability to object.
And so there are tactical or strategic options as to when that instruction comes from the judge, it sounds like. So the judge could do the instruction right at the time when the testimony is given, or could wait to the end when the defense rests, I guess, and then give the instruction. Is that?
Yeah, I mean, typically it's done at the moment it happens, or it's done at the end of trial. Military courts usually do it at the end of trial. And you have to be tactical about how you do it, right? Because there might be certain instructions you're entitled to, but you don't want at that time because it'll just draw more attention to a bad fact.
Yeah, but it also seems like they could forget. I mean, you could be given an instruction at the end, and if enough things have happened between the actual testimony and the instruction, the panel's thinking, what the hell are they talking about?
Well, that might be a podcast for another day about why it's important to have an instruction checklist with you in trial.
You think you could comment on that?
Yeah, I mean, listen.
You think qualified to comment on that?
I think I am qualified to comment on that. I always have an instruction checklist with me, and I usually ask my co-counsel or one of our experts to make sure they mark it as trial goes on, because you do forget. And instructions are one thing that I don't think we get a ton of. When I was an active duty judge advocate, we didn't get a ton of instruction on that. No pun intended, right? Instructions on instructions. We got some, but not a lot. And it's important. I mean, instructions can be cause for IAC, so you got to know your instructions. Now, I know we're getting towards the end of the podcast here.
We are.
So I want to finish with MRE 106, which is maybe the most important in terms of trial success, maybe the most important rule that we're going to cover in this particular podcast. Now, MRE 106 is known as...
We better edit that out.
Yeah, we better edit that one out. MRE 106 is known as the remainder of or related writings or recorded statements. This is very important. The rule states that when a writing or recorded statement is offered, an opposing party may require the proponents of the person offering it at that time to introduce any other portion of the document in question or an entirely different document when fairness demands. The object is to allow the finder of fact to consider documentary evidence or a recorded statement in its proper context as soon as it is offered. And I want to thank Dave Schlueter, because I read directly from the Military Rules of Evidence Manual, the 9th edition, on that particular topic.
If Dave is listening to this podcast, and I'm certainly not going to assume that he is, because he probably has much more important things to do. But Dave, we need to have you back on. You're always one of our most well-received podcast guests, so let's please make that happen.
And
didn't mean to get you off topic there, Robert.
Nope, not a problem. So
that's an important request.
It is. I've got to reach out to Dave. So what does that mean in a common sense way?
I don't know. My eyes glazed over about halfway through.
When the government offers a statement, whether it's oral or in writing, and they try to only offer a piece of that evidence, you have a right under MRE 106. I wouldn't call it a right. You certainly have the option under MRE 106 to stand up and say, wait a second, Your Honor. Hold on. The government just wants to admit into evidence time hacks, 1345 to 1922 of my client's statement to CID, but we've got 30 more minutes where he denies everything. In fairness, that ought to be considered by the panel. That's where I see it the most, where trial counsel tries to cut and piece together statements made by the client, by the accused.
Only what helps you, nothing that hurts you.
Correct. And the important part there, and this is important to understand, MRE 106 is not a rule of admissibility. In other words, you can't stand up and say on your own as defense counsel, Your Honor, I want the panel to hear my client's entire statement, and it's admissible through MRE 106. The judge is going to say, well, the trial counsel is not admitting it, so 106 is not applicable. MRE 106 works as, I call it, the piggyback rule. When the government utilizes their ability to admit your client's statement as a statement made by a party opponent or statement made by the accused, you can piggyback that rule and use it to get admitted other portions of the statement that, in fairness, ought to be heard by the panel.
Even if they otherwise might be inadmissible? Or
even if they are otherwise inadmissible, because, right, the rules, right, the ability to admit an accused statement isn't applicable to defense counsel. We're not allowed to admit our client's own statement under that particular rule. The government counsel is.
Yeah.
So it would be piggybacked basically into evidence through the government's use of their desire to admit into evidence a statement made by the accused.
So how would it work in practice? This is happening in real time in the courtroom.
There's two ways that it works. Either the government gets up there and they have the CID agent on the stand, and the CID agent goes through, yes, I recognize that CD. Yes, that's my signature on it. Yes, on that disc is the accused statement to CID from 12 February 2023 or whatever. Yes, that's an accurate copy. That this disc contains the accurate recording of the accused statement. Your Honor, we move to admit time hacks 1927 through 3814. Okay, if there's something you want the panel to hear in fairness, right? And the perfect example is sometimes clients will get a little confused with CID because they're interrogators and our clients aren't. And then later on they go, wait a second, I didn't even know you were talking. Of course I didn't do that.
Yeah.
You would stand up and you have the right at that point under MRE 106 to have the proponent introduce the entire portion of the video that's helpful to you, or you can wait for a later period of time, such as recalling the agent yourself and admitting that piece of evidence. I tend to let the government admit it at that particular time, and if I think it's something that could be so hurtful to my client, they might have a hard time getting over it, I'll say, hey, hold on. Article 39A, MRE 106, the whole entirety should be played. Or there's times where I go, yeah, let the panel find out the government's hiding the ball, and then let me be the truth teller on my case in chief, and I'll admit the rest of the statement. In my closing argument, I'll talk about how the government knew that statement existed, and they didn't want you to hear it.
Yeah, because if you do it during your case in chief, you're kind of the quarterback at that point. You're controlling
Correct.
What happens with the pace of the questions, the nature, right? So if you recall that investigator up, then
correct,
kind of can have your way with them at that point.
The other place where we see it a lot is text messages. The government wants to admit just a group of text messages between your client and his accuser that makes your client look bad, and they don't want to admit the other 25 text messages that make your client look good. That's another place where I've used MRE 106 successfully.
I think I could use that against you. So like when you send me a text message that says, Matt, you have no idea what you're talking about, then I could go back to like an earlier text message where you're like, dude, great idea. I loved it. What do you think?
If you say so.
You don't think it works that way?
It could. It could, if you say so, Matthew.
All right.
But the idea of the rule, man, like the reason the rule exists is you don't want one side to have an unfair advantage. Right. And that goes back to MRE 102. The purpose of the rules are to promote fairness. How can it possibly be fair if they're allowed to handpick and nitpick evidence to make your client look guilty? And then they go, wait a second, Your Honor, they're not allowed to admit their client's statement because it's a statement made by a party opponent and their client's not their party opponent. Or, it's a statement made by the accused. That right doesn't exist to the defense to admit that statement. That's obviously unfair.
I think the real importance here, though, is one, to know the rule and how it applies. But in the situation that you just described, Rob, you better know the facts of the case and you better know the statements. So in a situation that you described where somebody says something at one point and then they go back later on 10 minutes later and say, well, wait a second, that's not what I was talking about, and they make a correction, you as trial counsel better know that stuff cold, right? You better know the facts cold and what was said and what wasn't.
Yeah, well, I mean, if you invoke MRE 106 and a text message comes in that otherwise would not have been, the government, let's say they misread something, and you admit an admission from your client in the text message, you're going to be in big trouble. So yeah, of course you need to know.
Yeah.
You need to know what your facts are. I mean, listen, I feel my heart goes out to the TDS guys and the big bases and the ADCs and the big bases and the Regional Defense Council and the big bases who have a extremely heavy caseload, because court-martial work is getting harder and harder and harder and more time-consuming. You know, Capovilla Williams, it's not uncommon for us to put 2 attorneys from our office on one case, and you're talking about folks that have been doing it for years and years and years, because sometimes that's required because, you know, military practice is so formal. There's so many requirements. Just to file motions in a lot of these courts, the rules of practice are, you know, 37 pages long. I mean, I'm getting judges' pretrial orders that are 15 pages long.
Yeah.
You know, I feel for those guys with busy dockets that are also having to learn on the fly, because it is awfully hard.
So that means you're going to take it easy on them next time you're going up against them?
No, I'm talking about the defense counsel.
You're talking about defense counsel.
TDS. Yeah. Government counsel, I mean, listen, the Office of Special Trial Counsel has every resource available to them whenever they want it, however they want it.
Yeah.
So no, I don't feel as bad for those folks.
All right. Well, 100 series, is that a wrap on 100 series, or are we diving in even more?
Nope, that's a wrap on 100 series. Make sure you read it. Make sure you know it. It'll give you an advantage. It serves as the foundational building block of a lot of the other rules of evidence and a lot of these things that we see in court that we take for granted and we don't know where that authority comes from. And it will help you be a better trial lawyer. And listen, I've said it many times. I thought DCAP, when I was active duty, DCAP was great. I learned a ton from them, but I also would get up every morning early and I would read the Dave Schlueter's, you know, manual on the rules of evidence. It is, in my opinion, still one of the best resources out there, and utilize it. Utilize it. Don't just trust your SDC or your senior trial counsel or whatever. Make sure you actually get into the heart of this stuff, because when you do, you'll find things that'll give you an edge in the courtroom.
Yeah. Well, great episode. I know we've gotten some nice feedback and some nice compliments from some of the practitioners in the business on some of the stuff we've done along these lines. So hopefully they enjoyed it. Great episode, Robert. Thank you very much, sir. Next time we'll drag Mickey Williams in here out of the gym or out of a court martial to chime in as well. But to our audience, thanks again for tuning in. We'll have another episode out shortly. Until that time, everybody take care and be safe.
Thanks for listening to the Military Justice Today podcast with your hosts, Robert Capovilla and Mickey Williams. This show was made possible in part by the law firm of Capovilla and Williams. For more information or to listen to more episodes, visit militaryjusticetoday.com.